afternoon, everyone. Thank you so much for coming to our workshop today for copyright licensing, copywriting your performance art. We will be led by Kimberly Tignor, who's been doing a lunchtime series. Last week was visual art, this week is performance art, and next week is writing. We are also joined by our ASL interpreter, the fabulous Lanette Pinkard, and she will be signing for us today. And Kimberly will introduce her panelists. So if you happen to need ASL services, the best optimal viewing is to go to stop video at the bottom, press the little caret, and press video settings. Once you hit video settings, hit hide non-video participants. That way, you will only see the interpreter as well as those that will be speaking instead of all the little boxes across your screen. I'm going to go away, but I will be here to monitor the chat. Y'all have a good workshop.
Thanks so much. I appreciate it. So my name is Kim Tignor. I am the Executive Director over at the Institute for Intellectual Property and Social Justice, and I'm also the founder of an initiative called Take Creative Control. Essentially, we look at the disparate impact that intellectual property systems have had on marginalized communities. And I think that what is really, which is what led us to want to start our initiative, Take Creative Control, which goes directly into communities and engages and works with creative communities to make sure that they understand the value and the protections available for their creative works. You know, when I was approached by Artomatic, I was ecstatic because conversations about intellectual property, you know, folks, I feel like I say the word and people already start to fall asleep. And so the opportunity to sit and talk with creative communities, which are really the folks that we're looking to protect and engage, is always really special to me. And so today I wanted to have a conversation, about music and copyright and licensing. And I could think of what I was trying to think of, like my dream panel, because I know that this will live forever and be streamed and saved. I thought of Lita and I thought of Kokai because, well, first, Lita is someone that we've worked with a lot. She has been there at our clinics. She volunteers. She gives, you know, pro bono hours and is always willing to kind of just roll up her sleeves and help. You know, I always call her the artist advocate because she's just that person who's ready to step in and tick a whole lot of people off on behalf of her artists and the people that she's looking to protect. And, you know, Kokai, I saw him on a panel recently with a colleague of mine, and he was dope and was just dropping so much information and knowledge. I was like, I want to get this brother on a panel, and I can think of no better two people to kind of pair up because I think it's always important as we start to have conversations about intellectual property is to, one, bring in the perspective of like the legal and the policy, but then also bring in the perspective of the artists and the folks who are actually creating those works that we really want to protect and those voices that we want to empower. So with that, I'm going to open it up to Lita first to just kind of give a little bit of a background on copyright and just some of the things, you know, Lita, I feel like some of the things that you just have on that basic level when you first meet with an artist, or like that 101 on licensing and music and copyright.
Mm-hmm. So I think probably the most important thing for, you know, hip hop artists to consider, or musical performing artists, is the relationship with their collaborators. And I know today, a lot of times people are getting tracks, getting beats off the internet, and they're, you know, sometimes they never even meet the person, or they go through a service to get them. And that's probably the most important thing to consider. So renting tracks is never a good idea because you don't have exclusive rights. So if you create a hit song with it, somebody else can go and take that track and recreate your song like as almost a remix, and it's going to create a potential problem for you. If you otherwise typically the contracts that those kind of services or producers that are giving you tracks online give you are not the kind of contracts that really give you the kind of control over the creative work that you should have as a creator. Because if that song blows up and let's say a TV show, I mean, you may decide you want to do a deal with a major label. That's going to be a problem because you have to almost have a chain of title to show who owns the rights. And if you don't have a valid contract with them or an acceptable contract, that could blow up a deal for you. Secondly, let's say you want to keep your rights and you want to be independent, but let's say Coca-Cola wants to use your song in a TV commercial and you don't even have a way to get in contact with whoever did the music, then you're going to lose that deal because you can't properly represent to them that you own the rights in all of the music. And if you put the music out there without getting the rights, and I have a client in this situation now that gave music to ESPN and didn't get proper contracts with the people that created the tracks, and those people have sent cease and desist letters now to ESPN, and now it's created a whole legal problem. So what you have to do is make sure that you have a good chain of title to the works that you're creating. The other important thing to remember is that lyrics without music, without a melody, are really just a poem. They're not really a song. Right? So while you can copyright your lyrics, until you put it together with music, you don't technically have a song. And so that's something to consider. Then there's the whole question of splits and who owns the copyright in the song itself versus who owns the copyright in the master recording. And that's something that a lot of creators just don't really get. They don't get the difference between the rights in the master versus the rights in the underlying song. And a lot of people are confused in that regard about what they're supposed to get paid because they don't understand those rights. So there's two independent income streams that come to you from those two different rights. And a lot of people just talk about their writer share, which is they're cutting themselves short because your writer share is only even typically 50% of all the publishing income, but you're leaving all the money from the masters on the table. So a good way to think about it is, let's say if you were to download or stream, the money that you get for the master is the one stream of income. So it's easier to conceptualize with downloading than it is streaming. But if you download a song at Apple and Apple, someone paid 99 cents for it, the master owner gets that money, and Apple typically pays them 64 cents on the 99 cents. That's the money from the master. But then there are royalties, what we call mechanical royalties, due to the songwriters on the song that are typically 9.1 cents per song that have to get paid out of that 64 cents to the writers and whoever their publishing companies are. The other important thing is to make sure that you get your account set up at Sound Exchange to collect your performance income as a performer on a recording. And you get your account set up at ASCAP, BMI, or CSAC to collect your performance income as a writer or a publisher. And remember, there's two accounts that need to be set up if you own all your own stuff. You have to set up a publisher account at ASCAP and BMI, or a writer account, or else you're going to lose 50% of your money. Same thing with Sound Exchange. If you own your masters, you need an account as a master owner, and you need an account as the artist. Otherwise, you're letting 50% of your money go out the door.
Lita, you gave us a lot. That was, I was that was great. And
Too much?
No.
We'll have questions. We'll have questions, right?
Right. And so, okay, I want to shift to you and get your thoughts kind of on, I mean, there's so much, right? And this concept of music ownership and, the conversation, let's say 5 years ago on what it meant to own your music. And how that conversation has evolved, right, to present day. I'd love to just hear your thoughts on where that conversation was and where it is now.
Well, this is why I love somebody like Lita, because 10 years ago, 15 years ago, Lita was dropping these same gems. And it behooves you as an artist, if you want to stay happy in this music business, you have to first come to the realization that it's the business of music. It's a business. I love music. I've always loved music. I love creating music. I love performing music. I love everything about music, and I love the music business. Once you love the music business part, it makes doing the music a lot easier because you don't take anything personally, right? You start looking at how things are split. You start looking at all the intellectual property. You start thinking about ownership. You start thinking about legacy. Like, what are you going to be able to leave anybody if you kick off of this earth? Who's going to get that intellectual property? Who's going to be able to benefit from that? How are you going to be able to take care of your family, right? And so as an artist, I think that should be your responsibility, is understanding that as a creative, that's what you are. You now, what you are is a creator of content. You're not just a singer. You're not just a rapper. You're a creator of content. And if you create this content, other people want to have this content. And if they want to have this content, then they have to pay for that content, or they should be paying for that content. Mm-hmm. And when you create that content, you have to understand who owns what part of the content, right? To keep relationships nice, it's always great to walk in the studio and talk about splits. It's great. I know people say you're trying to kill the vibe and it's not right and all this other stuff. But seriously, if I know what part of the song that I've participated in, and you know what part of the song that you've participated in, when it's time for the check to come, nobody's confused, right? Nobody's talking about, oh, I thought I should have 50% of that. Or I added 2 lines. Don't I get 20%? Or I should get all of that is clear. And once you keep clarity in your life, like as an artist, you should be clear. Wherever you move, you should always be clear in what's going on. And ownership is super important, right? So 5 years ago, what artists should have been thinking about, or, right now, right? Let's not talk about, I like the juxtaposition of the past and the present, but we talking about moving forward, right? Because all the paradigms have all changed. And so going forward, what you should already be thinking about is everything that Lita said, right? Get you a book, take some notes, right? Record this conversation, stream it, look at it again, start figuring out what these terms mean. Because the sooner you find out what the terms mean, the faster you're able to understand when somebody's trying to pull something on you, right? And so I look at ownership. For me, I create most of my music, right? So, and if I collaborate, I go in with the mindset of, hey, how we splitting this thing off rip? Because I don't want anybody to be confused, and I don't like confusion, and I don't want to end up getting in a fight or a legal battle with anybody over something that we're supposed to be doing out of the love of the music, right? If you handle the business, that shows that you love them and you love the music. You're honoring that part of the creative process. And when you do that, you keep people from being upset at the end of the day. Because at the end of the day, like Lita said, if Coca-Cola comes along and says, here, we got $100,000, right? And you haven't cleared up that percentage, you basically just move that $100,000 out of your possession. Nobody's going to benefit. Somebody else is going to come along who owns every part of that song, and they're going to be able to benefit off of that. Similarly, just like with Lita's client, people who are music supervisors and those that go out and procure music, they always want to know that there's a clean record of who owns what. Because they don't want to, life goes at a fast pace. I mean, even in the midst of a pandemic, things are still moving, right? Yeah. And they want to be able to trust you. So if I come to you and say, hey, I own this product, they want to know that 100% I own this product. There's no confusion, right? And if I own a portion of the product, they want to know what percentage of that product do you own. They want to know that they can come to you in every occasion and ask you for music and be able to get that intellectual property free and clear without any issues, right? And this is how you build that reputation of being that person that a company or anyone can always come to get content from you as easy as possible. Nobody, we all talk about great artists and we always talk about great art, but we don't talk about how people can be difficult. So some of those great artists and some of those great situations, some people don't get the work because it's a difficult situation. If I know that you don't own everything, it's difficult. I can't rock with you. I can't buy anything from you. I know it's going to be a headache every time I go to you. You done got the song off the internet. You ain't do no clearance. Nobody has no clear title. I can't even, the contract look nutty. Like anything that you send me, the paper is trash. Like all of this, you don't have no attorney. You don't have no representation. You don't have nothing, right? It's just a jumble of chaos. I don't want to work with you no more. Like it'll be my first and last time ever asking you for anything. But over my career, I've been able to say, hey, I own this. I created this. Here's what I own. Here's my copyright. Here's my IPI numbers. Here's everything. I'm here. I'm registered as a writer and I'm registered as a publisher. I'm registered as a creator. I'm registered as an artist. Like I take care of the business. Like if you take care of the business part of it, that part makes it easier for you to move and be free and clear as an artist. Right. And I look at somebody, I know we talked about the De La Soul thing in preparation, and I look at De La's situation, right? Here you have them, they don't own their masters. And so now streaming services, and this is when you start getting into terms that I know Lita loves to hear, things like in perpetuity, right? When people start to own your stuff forever and ever, and ever, you can't do nothing with it because you don't own those masters. You can't go out and say to the streaming service, hey, I want to post these songs up without the label coming back. The label, Tommy Boy, came back and said they wanted 90% of everything that they was going to get paid. 90%. Why? Because they signed a trash deal when they were young. Now they could have went back and renegotiated that deal, right? Once they found out that they were De La Soul, but they might have been 6 albums in. Like, just because you signed to the label and just because you owe albums, if you feel like the terms are unfair, it should always behoove you to try to get up out of it, right? I would not have kept making records if my contract was trash in the beginning. Like, why am I going to keep making these records? We got to figure out a way that we could come to a better, if I've earned a certain amount of money, if I've, which you can put into your contract, you can earn your way out of certain, they give incentives. Like if you sell 500,000 copies, then maybe I own 50% of my masters. If I sell, 2 million copies, then I own 75% of my masters, or I could get that back before the 6 album term. Or, it's all ways to try to renegotiate,
right?
At the end of the day, but you have to be able to think about ownership. If you're an independent artist or you're an artist thinking about signing a deal with a record label, I always talk about like try to own as much of it as possible, right? And that ownership part is always going to come with what leverage do you have. You can't walk in the door of any record label if they invite you in or you walk in on your own volition. You can't walk in the door with no streams and no press and no pub and no quantifiable data that says you're the greatest and think that they just gonna give you your masters. It's not gonna happen. But if you build a buzz and you got the streaming numbers and you have all of the leverage, like all you need from the record label is their extra oomph, then you have a better bargaining position than if you walk in there with your hand out.
Right.
But I love that you ended it there though, because you're just gonna have to humor me on me looking at how different things are now, right? Mm-hmm. Because now I see independent artists who are able to build that buzz online before they have their first conversation with a record label, right? And I think that it's really interesting how it's caused this major shift in the industry. And so I feel like that was, before the pandemic, before COVID,
right?
That was the fascinating thing. But now I feel like even more as we're moving virtually and engaging that way, I would love to hear what you're thinking or what your thoughts are as far as what artists should be thinking about as they're engaging more and building their platforms more online.
Well, that's true. And Kokai is absolutely correct about, having some quantifiable way to show your success when you walk into a label. But I tell you now, the labels are awfully advanced in what they do. And they have a new trick that they use for that. And the new trick is they give you a joint venture deal that says you own your masters and you're splitting the money with them. They might even say they're splitting it with you, 60-40 to you or 80-20 to you. But then they put an option in the contract called an upstream option. That's their option. And if they exercise the upstream option, then the contract reverts back to a traditional deal where they own everything, and you're back on a sharecropping royalty structure. So you've got to be really careful. The other thing is that, not every lawyer, so in general, most entertainment lawyers all learn how to do things the same way. And they accept kind of the standard agreements that record companies and publishers and everybody else want to push in front of you. And what they push for is to get you a bigger advance. And I don't know the De La Soul situation, but I would presume, because I've seen it so many times, that once they had success, all their lawyers did was got them a bigger advance, which just puts them in hock further to their record company, instead of going in to change the structure of their relationship, as Kokai was mentioning, to be more of a joint venture where they have ownership and control of their masters. And that's what I see typically happening, right? So the lawyers think it's just time for a payday. We're going to get you a big check. And the artists are just happy to get a check, and they're not thinking. So what I usually do, and Kokai's right, if you don't have some really demonstrated success, and it's important to know that that bar of what they think is success keeps increasing, because there's more and more artists out there that are coming in with, 100,000 streams or 100,000 views on YouTube. And while that used to be enough, 3 years ago, now that's not enough anymore, because too many artists are showing those same numbers. So the increments of what looks exciting to them and what they want to sign is changing, right? And so what you have to always be aware of is making sure that you have as your goal your ownership of your masters, and you communicate that goal to your lawyer. And what I do with my clients is, let's say we sign a typical record deal, or even one of those new deals that have the upstream option. What I point out to the client is, here's the laundry list of things that we need to change if you get some success. We're not just going to go in and ask for another check, because guess what? Your royalties are coming anyway. I saw happen to Britney Spears, who sold, 10 million records. And what the record company, Jive Records, did was, right before her royalties were due, they gave her a huge multi-million-dollar advance. If she had just waited like a week, she would have gotten that money in a check as royalties and been out of hock. But instead, they gave it to her, and this is something they do. So know when your royalty statements are due. Don't go in and take an advance, right before your royalties are coming out. Have some patience, right? Patience is key. Have some patience to wait for your royalties to come in. The same thing we're doing publishing deals. Everybody wants a publishing deal, but guess what? Publishing deals are another thing that gets you in trouble. I know some big, well-known producers that everyone here would be so surprised to hear they have not gotten out of their first contract period with their publishing company, because the minimum number of songs that they have to deliver, they can never deliver that many songs, because the way the publisher structure the deal, and they get stuck in their publishing deal and can't even get into their second. It might say the deal's only 3 years, but they get stuck in their first contract period for 20 years.
I just had a friend he went back and renegotiated his deal, his chattel slavery publishing deal. And he did it strictly on the back of Black Lives Matter. Seriously. He went in and threatened them, like, with the, you treat me like.
I've been actually using that in my negotiations with the labels. I remind them, we're in the time of COVID-19 and all that just happened with George Floyd, and everybody's trying to do right, and the record label executives are on the news and putting out press releases. So let's see some real action. Let's see you treat artists differently in terms of how you do business, right? Let's get some ownership. Let's get some fair splits of income, and let's try to really restructure these situations. So it's important. And it's important to know. The other thing to know about renegotiation is when you do it, right? So, and the other important thing is, you don't turn in your music and then ask to renegotiate. So once your album, you put out one album, don't keep giving your label music. Keep that music. I don't care how much you like creating. Keep that music in your own studio. Don't give them new music until you've gone in to renegotiate the terms of your deal. Right? They want to, and now this the other trick is the mixtape.
Oh, Lord.
So they put out one album and 20 mixtapes, and keep telling you you're in your first contract period and you haven't delivered your second album. And they keep you stuck in your deal, and they're making money off mixtapes while you're trying to figure out why you can't get another advance and why you're still unrecouped. So all these things are important on the major label side. On the independent side, it's important, I think most importantly, as Kokai said, to get it together, learn the business, okay? People, everyone's always going to take advantage of you if you don't know business. If someone's using language and you don't know what it means, Google it. Look it up, figure it out. There's plenty of books out there. Understand what people are talking about and know where your money comes from. If you owned a store, a corner store, you would know how you make money, right? When you're in the music business, you need to know how money is made so that you can get your fair share of that money.
Right. Bars. See, this is what I'm talking about. When you said she just all gems, all jewels, all day. This is what you're gonna get.
This
right?
title has reminded me how much I've missed Lita.
No, I mean and that's absolutely the same space that I ask artists to operate in. You got to operate this way. There's nothing wrong. I have a good friend who is a songwriter, and he took crazy advances, Bugatti, Ferrari advances, right? And he and I had a conversation recently, and he was like, yo, man, I should have never done that. I should have told him to pay my rent for a year, right? Instead of giving me the advance money, just pay for my space and pay for my studio space. Or how about I don't take as much of an advance? I take less money. Right? Because you can always take less money. Right. You know, I think that's the part when you talk about patience, is that if somebody is throwing $500,000, $1 million at you, what does that really mean that you're gonna make? Right. If you give me if 50K is gonna keep me floating, I'll take 50 because I can earn out of 50 faster. Right. And then don't do anything like some insane, you need 200 songs a month kind of nonsense with a publishing deal. What kind of craziness? God. You know, they have these kids out here writing like it's crazy. It ain't enough ink in a pen. It ain't that many notes pages in your phone. Like, leave it. You can't do crazy, insane things. But people believe that a publishing deal is just going to get them all. Well,
they think publishers are going to play songs for them and get them movie licenses and TV commercials. And publishers don't do any of that. They don't do any of that. All they do is collect money for you. Any publisher who tells you they're going to get songs placed for you, they're not telling the truth. The truth is that the people who get songs done for you and marketed is on the record company side. That's who can get that done. So if you're offered, let's say, a 5-song deal as a producer versus a publishing deal, take the 5-song deal. Because getting those songs on the market is what's going to create money for you. The more music you have out on the market, the more likely it is that one of those songs will pop and that you'll make more money. So you can't keep your music under your pillow. You can't be afraid. You got to get it out there. But if you do the right thing and copyright it and do the things that you need to do, then you can be in a position to actually make money from the music that you're creating.
Absolutely. And it's about relationships. So a lot of the things I'm an independent musician. I've been an independent. I was signed to BMG France. So here's my story. Signed to BMG France. I still owe Sony money. Why? Because we were jointly and severally liable for the advance that we all got. So Sony can't find my friends, but their letters keep showing up at my parents' house. Right. And so for 2 decades, I've been owing Sony the advance that we got when we first signed to BMG. Right. And so that's still in existence. If I ever sign another deal with BMG, I did a song with GoldLink on his album. They didn't come get my check. They could have, honestly, because I'm jointly and severally liable for that money. But, you know, that's why I'm very, very cautious now, because I signed a trash deal and I get it. And I never want anybody else in that same position to ever go through that again.
Right.
But also, as an independent artist, a lot of the things that have happened to me have been because of relationships. The 6 songs I got in Kevin Hart's Laugh at My Pain happened because I own my masters. I own my own stuff. And I could negotiate the deal with the company that wanted to place those songs in that movie more so than anybody else. I could advocate for myself. I knew what I wanted in the contract. I knew what sort of splits I wanted. I knew what sort of numbers I wanted. And I had the right paperwork to show that I owned everything. Right. And then I have relationships with friends who are at MTV. That's how I got the MTV stuff. I got friends at record labels now. So what I do is I just talk to my friends. I don't do a lot of let me go through the publisher for this and let me go to this, that. I just talk to them and say, hey, you know, what's going on? What do you need? Do you need something? Let me know what you need. And they trust me because they know, A, I'm probably not going to show up with any samples. because I
Right.
don't want the headache. So I'm not going to show up with any samples. If I do show up with samples, and this is the part, if you're a producer and you have samples in your music, show up with the right publishing information, right? Not just George Clinton made the song, not just whatever. Who owns the publishing? Who's the publisher? Who owns the rights to that song? Right? Have the year that the record was made, have the song that you sampled, have the writers that were on that song. All the information is on that record, right? So you can write all of that stuff down and go clear it or attempt to clear it.
Right.
Or
And
you-
it typically takes 3 to 6 months to clear a song.
Right.
So that's the other thing you have to be aware of. It typically takes 3 to 6 months to clear a song, and sometimes longer. So,
Right.
you know, you're saying I'm getting ready to, like, I had a client come to me that had used a bunch of jazz music on an independent project that everything needed to be cleared, and he and his family were investing, and they were like, well, our release date is next month. I was like, well, you're not going to be able to release any of this music next month. You got a sample on every single song from a major jazz artist, and you're going to have to pay to use these samples. You're not releasing this next month. So those kind of things are really important to, you know, knowing, you know, just from a business standpoint, where you are and where you're trying to go.
It would have been easier for them to reach out to the jazz artist to have the person actually replay the stuff than it is to go to try to get it cleared.
Or just use
Honestly.
another artist.
Or just
to
use an
replay
artist
it.
that- right.
And then they only have to clear the music, the song, and not
Right.
the masters.
Right.
So, you know, that's the whole other thing. If you're using a digital sample, you have to clear both the master and the song itself for the song itself. We would be remiss, though, today if we didn't talk about copyright termination or revocation of rights and recapturing copyrights under the Copyright Act. And I think what's most important is that on the publishing side, as long as your contract didn't say it was a work for hire, which most publishing contracts do not say that, unless it's like you're writing jingles or you're writing music for TV, theme songs and things like that. Usually there's no work for hire. Basically 35 years after you've written the song, you get it back. Or if the song was released before January 1, 1978, 56 years after the song was released or you signed an agreement, you can get your rights back. On the master side, it's a bit more complicated. And there's actually 2 class action lawsuits pending in New York, one against Universal and one against Sony, where there are a group of artists who are trying to enforce copyright termination provisions to get ownership of their masters back from the record companies. And the record companies are fighting it feverishly. And most likely those cases will end up at the Supreme Court. At this juncture, the district court, the trial court entered some rulings that are in favor of artists. They said that technical inconsistencies or technical errors, minor errors in your notice, because you have to send whoever owns the rights a notice that you're terminating, and it has to be sent to them at least 2 years before the date of termination. You have to use a lawyer or a service to do your terminations. You can't do them on your own. It's too complicated, but still you should get them done. And artists should know that. I think for now, if you're out of luck if you didn't send your notice and your works were, you'd signed your deal or your works were created in, I think, 1981. So you're already out of luck. We're up to like 82 now in terms of who can terminate. But the other thing the court said is that the work for hire language in recording agreements should not prevent an artist from exercising their termination rights. That's the good news. The other thing that the court pointed out is that if you use a corporation, an LLC or a company, to enter into your recording deal, you cannot exercise your termination rights.
Oh, wow.
Now, most artists want loan out companies. You go to entertainment lawyers, they say, oh, we're going to set up a loan out company, which is a company that's your company that you set up to enter into your recording deal with the record label, whether it's an independent label or a major label. If you do that, you lose your termination right. So your record deal has to be in your individual name, or if you're in a group, in each individual's name in order to exercise your termination rights. You can direct your money, your income to go to a company that you set up. You can perform live under that company. You can sell merchandise. You can set up your fan site. But in terms of your actual deal with the record label, And that most likely is going to be upheld by the Supreme Court. So the other thing that, the other significant issue that came out of that case is that for what they call gap works, which means that, let's say you sign, so the 35-year rule is for recordings that were made after or music that was created after January 1, 1978. But let's say you sign your contract in 1974. And your song was released in 1979. So you're in between the 56-year and the 35-year termination. Those gap recordings don't have any protection for termination. So we need Congress to fix that. And hopefully we get Joe Biden and Kamala Harris in there, and we can get in there and get some copyright legislation that will help artists with that particular problem, but that's another problem. So just remember, for De La Soul needs to send their notice of termination to get their rights back. And a lot of other artists need to do that too. And the Taylor Swifts of the world have to be in a position to negotiate. I think that she just didn't have good lawyers negotiating for her to get her rights back. Right. She should have sought her rights at a critical point in her career. Timing is everything, right? So there was some point in time where she could have got those rights, but it looked like that window closed on her. With all of her success, there's no way that she couldn't have gotten her rights back. I just can't believe it. There was something that could have been done, but her lawyers really weren't on board to renegotiate. They probably just kept getting her money instead of saying, forget the money, we want the rights.
Right, exactly.
Lita, one of our participants has a question. Stephen wants to know, so the liability limitation in LLCs, they come at a risk of losing termination rights?
Absolutely.
Okay. Look at that. That was
absolutely. Absolutely. So you don't want to set up or a corporation, whether it's an LLC or a loan out, whatever type of company it is, that company can't sign your recording deal if you have a work for hire provision. Now, if you negotiated to own your own masters, it doesn't matter, right? Because there's no work for hire provision, so you could still terminate. So that's, this is why you need a lawyer, because there's a lot of nuances to these things that are going to be difficult. You should know, as an artist, you should have a general idea of when there's an issue, but really you should have your legal representation and your management there to assist you to make the right decisions.
And be careful about the lawyer thing that every lawyer is not an entertainment attorney. Right. So there's certain nuances, like somebody in the personal injury may not be your best
or
person.
A criminal lawyer,
lawyer.
Even some of the major entertainment lawyers might not do you right, because oftentimes they have conflicts of interest. Their family members work at the labels, and Clive Davis has like 5 or 6 different family members who are entertainment lawyers, right? And everybody might think that's the best lawyer to get, but there's also some risk that comes with that in terms of how your deal is going to be structured. So lots of well-known entertainment lawyers don't necessarily, especially if they shop, meaning that they try to get deals for people, they're not necessarily the ones that are going to be real zealous about getting you ownership of your copyright. So you need to think about those things.
Yeah, be careful.
That point, Lita, and Coque, I think you guys both said this, kind of touched on it earlier. It should always be a major red flag if your attorney is not ready to sit and make sure you understand all the terms, everything.
That's it. That's what you pay that retainer.
Right. And read your contract. Read it. Don't just hand it to your manager and your lawyer and say, take care of this like you're some big shot. Because contracts, I don't care what industry you're in, contracts are the blueprint for your business relationship. And if you don't understand what's in your contract, you're not going to understand your business relationship.
Absolutely. It's like when I'm on tour, when touring was a thing way back in the olden days, you have this thing called a rider. And that rider is basically a piece of paper that I normally include in my contract when I go into a contract with a venue to go do something. And that rider basically says, this is how I'm supposed to be treated. Right? That's basically what your contracts
are. And this is your sound and lighting requirements.
Exactly.
This is a bunch of stuff. This is when a bunch of things need to happen.
Right. Right. And if you don't have that, but once again, like I said, I'm just comparing that to your record contract. It's how you want to be treated, right?
That's
In
right.
terms of this business relationship, because it's a relationship. You know, you just don't go get married to random people and not find that you don't not go on a date. You don't not, I mean, unless you have an arranged marriage, I mean, you normally try to suss out who that individual is by spending time with them. That is what your contract is. Your contract is how you want to be treated in this relationship. In this business relationship, how long are we supposed to be doing this? In this business relationship, how much am I supposed to get out of this thing? You know, in this business relationship, what are you supposed to be doing versus what am I supposed to be doing? And when do I owe that? You know, and just like Lita said, the mixtape hustle is a hustle. You know, I've seen artists get, you know, turn in 50 songs and they're like, oh man, that's not an LP. I'm like, that's several LPs. But they're like, nah, you need a mixtape because you need to build your da-da-da-da-da. And prior to the changes that just happened with the Recording Academy, that used to push people out of contention to be best new artists because they had too much work coming out.
Mm.
But no longer, you can't be penalized for that any longer. But it's just one of the things that's there. It's a tool of the record label
Right.
to keep you from collecting, because what they do is they identify, if you do an EP, your percentage of that is this. If you do an LP, your percentage of that is this. If you have contingencies set up so that if you sell a certain amount of LPs, right, and they keep saying that you did mixtape, and even if your mixtape does LP numbers, they're like, but we designated that a mixtape. So it doesn't help you get out of your contract. You owe 7 albums, and they define an album a specific way. This is why it's great to read your contract, because in that contract, there are definitions and terms that tell you exactly what you're supposed to know. So if they say an LP means that this has been identified as an LP and all the songs got to be over 21 minutes and da-da-da-da-da-da, and you turn in something that's different, they're going to be like, that's not an LP. Or if your A&R designates that as a mixtape, then you're going to be looking goofy. Because you're sitting up there like, oh, I thought I turned in an album. And they're like, but it's a mixtape. And that's when you got to fight back and be like, no, it's not. Mm-hmm. That's why you don't turn in. You know, I love the Tupacs of the world. I love some of the other artists that used to go in the studio and record 200 songs. I love you. I love you a lot. But like Lita said, don't turn none of that music in. Sorry. You're getting 12 out of me. You're going to get 14 out of me. And even if I went and recorded 50, you're going to get 14 out of me. That's what you're going to get at the most. And if you say, I don't like these 2, I'm going to give you 2 more. That's it. Here's 2. I'm not going to give you the other 200 songs that I recorded. You probably never see those. I tell artists most of the time, like, seriously, don't even, if you go in and you're recording under a recording contract with the label, go in with your own hard drive.
That's right.
Buy your own hard drive, not with that advance money. Go in with your own hard drive.
Right.
Once you finish
and play
recording,
the music for them.
That's it. Walk out with your hard drive. You walk into the studio with your hard drive. You walk out of the studio with your hard drive. You play the music in the studio. You don't come there. I'm not sending you no extra files. I'm not sending you no MP3s. We can come to the office. I play it off my phone. That's what's going to happen. Because you're not going to get these 200 songs. It's not going to happen. Right. Because next thing you know, you have some crazy, goofy mixtape out there, and not really. You got 7 albums worth of material. You've written all the albums that you owe the label, but they're gonna hit you with the mixtape hustle. Don't do it.
So can I tell you guys, I cannot thank the 2 of you enough. Like, honestly, I feel like a lot of these gems y'all been dropping are like larger metaphors for life. Like, bring your hard drive. I'm gonna give you 14.
That's right.
Thank you, guys. I'm going to make sure that everybody that participated today, we're going to work, Natalie and I will work to make sure that everyone's able to find you all online and your bio, everything like that. And I can't thank y'all enough. This has been fantastic.
No, thank you. Appreciate it.
I took notes. Y'all were dropping some serious gems today. So thank you.
Thank you.
All right. Love you, Kokai.
I love you too, Lita. You be well. Lita and I go back. We go back.
Love that.
Car seats.
Thank you, guys.
All right. Bye-bye.
Take care. Ciao.
Thank you all. Thank you.